Good day, everyone. My name is Jessie, and I'll be presenting on one of the oldest principles in land law. This Latin phrase means whoever owns the land owns it up to the heavens and down to the depths. My presentations today will evaluate how this maxim is interpreted in modern English land law, especially in light of technological developments and statutory reforms. And also we'll focus particularly on the impact of Bacardo versus Star Energy 2010 on the ownership of subterranean space. Traditionally, this maxim illustrated that land ownership was three-dimensional, extending upward into the air and downward into the ground. Under Section 205, subsection 1 of the Law of Property Act 1925. The term land includes land of any tenure together with buildings, mines, minerals, and other physical parts of the land. This statutory definition supports the idea that a landowner possesses both the surface and everything attached beneath or above it. The earliest recognizations of this idea can be traced to Bury versus Pope 1586, which confirmed that a landowner had full control over the airspace and subsoil within the boundaries of their property. At this time, the law assumed that ownership was absolute, where there were no aircraft, pipelines, or underground systems to challenge this belief. However, modern scholars such as Gray and Gray in Elements of Land Law 2020 argue that this maxim now carries a symbolic rather than a literal meaning. It continues to express the conceptual unity of land, but its practical scope has been restricted by statute and case law. In history, land ownership was tied to wealth, power, and social standing, particularly during the feudal period. The maxim reflected a system where property rights were absolute and any interference was seen as trespass. The case of Bury versus Pope 1586 demonstrated this literal interpretation. The defendant was permitted to build on his own land even though it blocked light from his neighbor's window, because his control over his land included the airspace and above it, as it was seen as absolute. Later, William Blackstone reaffirmed this idea in his commentaries on the Laws of England 1766, famously describing property ownership as extending to the heavens and to the center of the earth. This shows that during the medieval and early modern eras, property law gave landowners full dominion, and such total control made sense when the world had no airplanes, drones, oil drillings, or public pipelines. However, as time passed, this nation became unrealistic. Gray and Gray note that the absolute idea was based on historical necessity, not unchanging truth. As society developed, ownership had to adjust to technology, leading to today's restricted understanding. Moving into the modern era, the courts and parliament have reinterpreted the up to heavens part of the maxim. Modern law now divides airspace into two zones: lower airspace, which belongs to the landowner, and the upper airspace, which is open to public navigations. The courts protect the lower airspace when interference affects the landowner's ordinary use of the surface. In Kelson versus Imperial Tobacco 1957, a signboard that projected only a few inches into the claimant's airspace was still held to be trespass, even though no damage occurred. The principle was reaffirmed in Anchor Brewhouse Developments versus Berkeley House, where the movement of a crane arm over the claimant's property also amounted to trespass, even without physical contact. However, in Bernstein of Lake versus Skyviews, 1978, the court limited this rule by holding the taking aerial photographs from a reasonable height was not considered as trespass, while the judge, Griffiths J., stated that ownership of airspace is restricted to the height necessary for the reasonable enjoyment of land. This view is supported by Section 76, subsection 1 of the Civil Aviation Act 1982, which provides that lawful flights or aircraft over land shall not constitute trespass or nuisance. Together, this case and statutes demonstrated a clear movement away from absolute control. Landowners today only control the airspace they can use, while the rest is treated as part of the public domain. The second half of the maxim, which is down to the debt, also have been reconsidered in modern law. The leading authority here is Bacado versus Star Energy 2010, which is important for this presentation today. Okay, so in this case, the defendant oil company drilled diagonally through the land owned by Bacado, between 800 to 2,800 feet below the surface, in order to extract petroleum under statutory license from the Crown. The Supreme Court held that a trespass had occurred because the company had physically interfered with the subsurface of Bacado's land. However, the damages awarded were only £1,000, reflecting the limited practical value of the deep layers involved. This case clarified that a landowner's right extend beneath the surface, but only to a reasonable depth, where interference would actually affect the use of enjoyment of the land. The Bacado decision fits within a wide statutory framework that limits private ownership for public benefits. Under Section 2 of the Petroleum Act 1998, all petroleum within Great Britain is vested in the Crown. Furthermore, Section 43 of the Infrastructure Act 2015 provides that drilling for gas, oil, or geothermal energy at a depth of 300 meters or more below ground level does not constitute trespass. These legislative provisions reflect a balance between private rights and national interests. Bacado therefore marks a turning point. It confirmed that subterranean ownership still exists, but only within functional and statutory limits. It ensures that energy development can proceed while preserving landowners' right near the surface. When we consider both airspace and subsoil, the maxim clearly continues to play a symbolic role rather than a literal one. Modern courts use it as a foundation for reasoning, but ownership is now restricted to what is reasonably and necessary for the enjoyment of land. Cases such as Bernstein versus Skyviews and Bacado versus Star Energy illustrates this balance perfectly. They show that the law still protects landowners, but within practical limits that accommodate the needs of society. While statutes like the Civil Aviation Act 1982, Petroleum Act 1998, and Infrastructure Act 2015 are key examples of how Parliament has adjusted the private property rights to allow for aviations, energy extractions, and other public interests. Scholars such as McGarry and Wade in the Law of Real Property 2019 describe this as a shift from absolute dominion to relative enjoyment. This means the law protects ownership only to extent that it is useful and fair in a modern interconnected world. Ultimately, land law today reflects a compromise where it balances private ownerships with technologies, progress, commercial use, and the collective needs of society, which makes a more justice and fair. And that's all from me. Thank you for your patience.